McCreary, Veselka, Bragg, and Allen PC, as well as MVBA LLC. We're here today on an FDCPA case exploring the current state and application of Article 3 injury, as well as class certification. The underlying facts of this case were that MVBA LLC, who is a collection agency, sent a collection letter.
We know the underlying facts, and you may certainly refer to them as you make your arguments, but we've read the briefs. So.
No problem. One critical fact is that Ms. Perez testified that she had no actual harm, but she was confused about the letter she received. This appeal came here based on a class certified on 55 people who received the same letter, and then about 2 weeks ago, this court sent out a notice that asking the parties to address plaintiff standing as well, besides the class. The history of standing has really stepped on the gas in recent time. In 2016, the Supreme Court ruled on Spokio versus Robbins, bringing forward the true need for a concrete and particularized injury. Spokio court said the allegation of bare procedural violation cannot establish injury and standing. A few years later, the Seventh Circuit in Casillas versus Madison Avenue, Judge Coney Barrett penned an opinion stating that even if a collector under the FDCPA failed to comply, it does not equal FDCPA standing. That case led to a whole progeny of cases within the Seventh Circuit applying Casillas, finding very similar results. In 2020, the 11th Circuit in Turchell versus Midland Credit Management, continuing this line of cases of Article 3 standing, held that the FDCPA suggests no congressional judgment firm enough to break with centuries of tradition indicating that misrepresentations are not actionable absent reliance and ensuing damages. And that is a case where the risk never materialized. Last, in 2021, Supreme Court brought up the topic of Article 3 standing again in the TransUnion versus Ramirez case, which was an FCRA case, Fair Credit Reporting Act, which has very similar applications to the Fair Debt Collection Practices Act, as we're here on now. The Supreme Court came out and said it very bluntly, no concrete harm, no standing. It also required a close relationship to traditionally recognized harm in common law, such as whether the provision of the statute had elements of like defamation, intrusion into privacy, intrusion upon seclusion. TransUnion case also dispelled standing for just a risk of future harm. The last key piece of TransUnion was that the court said that every class member must have standing in a case.
As I understand it, the district judge here just cited TransUnion in a footnote and maybe distinguished it factually. Is that, I mean, correct me if I'm wrong about that.
You're absolutely correct. The court, we filed a notice of supplemental authority regarding Ramirez, and the court issued its opinion the next day. The court addressed Ramirez in a simple footnote, as you described, simply saying that, well, Perez received this letter. It was the same letter sent to the class. Therefore, the class stands in the same shoes as Perez. However, that made too many presumptions, and I'll get into kind of the relation of this court's case in Fletcher versus Metacredit in relation to that, but the court made too many presumptions with that kind of quick brush off of TransUnion that the class members did the same thing as Perez, which was receive the letter, read the letter, react to the letter. And there was no evidence presented to the district court of any of those subsequent steps happening. The only thing the court identified was that the class members were simply sent the same letter. I'll first address Ms. Perez's standing based on the court's notice to provide information or argument on that as well. And obviously our position is Perez doesn't have standing just as the class does not. In Ms. Perez's complaint, all she alleged was that she had a significant risk of harm, or a significant risk of future harm. But as I stated in her deposition testimony, she merely said that she was confused by the letter. She actually stated twice that she had no actual harm. I think that statement alone, no actual harm, establishes that she does not have standing under the Act. But focusing on the confusion, which the district court relied upon to find her having standing, courts have held that just simple informational harm does not amount to concrete and particularized injury under Article 3. A simple approach I think this court can take in the analysis of Ms. Perez's standing was a Northern District of Illinois case that's cited in the briefs, Tataru versus RGS Financial. The facts in Tataru versus RGS Financial were that RGS sent a collection letter to Mr. Tataru, and it identified the creditor as FNB Omaha Roman numeral 2. The allegation in that case was that's not identifying the proper creditor. The proper creditor is First National Bank of Omaha, and no entity named FNB Omaha Roman numeral 2 exists. The district court initially found that it did not properly identify the creditor and certified a class on that. The cases spawning out of Casillas versus Madison Avenue were all released around the same time as this opinion. We filed notice of supplemental authority and a motion for reconsideration in that case, and the court actually reversed its initial ruling and ended up holding that Mr. Tataru only suffered a informational injury and reversed itself. Mr. Tataru in that case had testified that he had read the letter and was confused by the letter and thought it could be fraud because he did not recognize FNB Omaha Roman numeral 2. And the court looked at that, looked at the testimony, saw that that testimony could not match class members and therefore a class couldn't be certified. At the same time, looked at the standing cases that had been released around that time and said just a mere confusion without any reliance upon the effect of the letter creates no Article 3 standing or harm, and the court dismissed the case on standing. I think that case applies directly to this case here. We talked about the effect of the letter that it had on Ms. Perez. She simply stated she was confused, and she suffered no harm from that confusion. All she did was read the letter, testify that she was confused, and she took that letter to her attorney because she remembered something about statute of limitations and brought it to his attention, whereby a lawsuit was filed on her behalf and a class. More complicated approach to standing would be really the application of TransUnion along with the traditionally recognized harm. In TransUnion, that case really had to do with underlying common law of like defamation, where in the TransUnion case, TransUnion was maintaining individuals' credit files with a notation that the person could be a potential terrorist. The Supreme Court, or actually the district court, divided this class into two categories. One category meaning the people who had this flag where that information was disclosed to people, and the class where that information was not disclosed to anyone. And so applying defamation, the class where that information was not disclosed to anyone, there's no publication as an element under defamation, and therefore that particular class had no standing under the traditionally recognized harm. In the case we're here on today, I believe that the traditionally recognized harm under common law would be fraud or fraud by non-disclosure, because the claim at issue is the letter was sent on a time-barred debt and did not include a disclosure that the debt was barred by the statute of limitations, and therefore it could not be legally enforced. Therefore, you have the elements and arguments of misrepresentation by the letter, but what you don't have is the critical elements of fraud or fraud by non-disclosure of detrimental reliance and damages caused by that detrimental reliance. All you have is her statement of confusion, which does not fall into those two elements of that underlying traditionally recognized harm. Without any reliance, based on that statute of limitations disclosure not being present, here we do not have a payment, which is kind of what you would normally think of as the detrimental reliance on the lack of a disclosure. Ms. Perez did not make a payment, no evidence of class members making a payment, and therefore there is no article standing for Ms. Perez or the class under that Ramirez approach.
There's not even any showing the members of the class opened the letter, right?
Correct. And so that's kind of the next step I was going to get into is the class standing itself. Even if Ms. Perez somehow has standing, the class cannot. And that ties into this court's opinion in Fletcher versus Metacredit in 2020. In Fletcher, it involved another FDCPA case where a letter was sent and it involved whether or not the letter made a threat of legal action upon the recipient. And in this court ruled in Fletcher that the underlying case did not meet Rule 23 standards under commonality, and therefore did not make an actual ruling on whether or not the class had standing. However, this court went on to address standing without a ruling by stating that the standing issues in this case are real. Countless unnamed class members lack standing. Our court has not yet decided whether standing must be proven for unnamed class members in addition to the class representative. But some circuits have held that no class may be certified that contains members lacking Article 3 standing. The court went on in the next paragraph. That is significant because there are undoubtedly many named class members here who lack the requisite injury to establish Article 3 standing. After all, the putative class sweeps in all persons in Texas who received a form collection letter from Metacredit. As a result, the putative class inevitably includes people who received the letter but ignored it as junk mail or otherwise gave it no meaningful attention and therefore lack a cognizable injury under Article 3. That applies directly to the case at hand. In the case at hand, no evidence was presented to the district court of any injury whatsoever by the class members, and frankly for Ms. Perez as well, and there cannot be one. This court further stated courts must certify class actions based on proof, not presumptions. And what happened is the district court simply made that presumption that it mentioned in the footnote that Judge Smith brought up that these class members actually received the letters, but then even took additional steps of reading the letter, having an effect of the letter, and so on.
As I understand it, this court has not ever decided whether before a class is certified, the plaintiff has to show that the absent class members have standing. That's something that we've not held.
Correct. The closest the court has gotten is Fletcher versus Metacredit. To take a step further,
Would this be the appropriate case for us to decide that?
I believe so.
Or do we even need to reach it?
It kind of goes both ways. I think the root issue is really whether Ms. Perez has standing and she doesn't, and I think that is the first analysis that has to be made. I think the analysis on Mrs. Perez having standing equals she does not have standing, and therefore the class isn't addressed. However, if this court holds that Ms. Perez does have standing based on confusion, I don't think the class has standing, and it can be, well, I back up, that the class goes away based on either Rule 23, similar to Fletcher, or the class goes away based on standing. It depends on which, I guess, step the court feels most appropriate to be the first step. Lately, the first step has seemed to be just the threshold of standing itself to find out if the claim even belongs in federal court. I'll address the Rule 23 requirements as well. Standing or not, the elements of Rule 23 are not met. Under commonality, there's questions of fact that differ here. The questions remain to the plaintiffs. Was the letter received? Was the letter read? What effect was there? And therefore, there are too many individualized aspects for each of the class members to be addressed to know whether or not there can be a class. Again, the district court unfortunately glossed over these questions and simply swept them into they were sent a letter just like plaintiff was. Typicality, the answers of all those questions I just stated can differ, and therefore the case does not meet the element of typicality as well. Lumping those together, predominance, no actual harm has been shown for these people, and so like Ramirez, we have no idea about alleged harm until these people come forward. I jumbled that a little bit, but it's very similar to TransUnion, where a lot of these class members would only learn of harm once they received a check for compensation. And that is addressed in the TransUnion Ramirez case. Again, applying Fletcher to this case, it really does appear that the court just made too many presumptions to find standing for this class. And as the court stated in Fletcher, you cannot base a class merely on presumptions. Too many presumptions were made in this case that improperly certified a class. Last, to address a few miscellaneous arguments that have been brought up. One argument brought up by Applee has to do with the mailbox rule. However, a mailbox rule only makes a presumption of service of a letter itself. It does not continue on anything past that. We're typically used to the presumption of service being made of pleading or discovery or something like that. But that service doesn't actually mean that the recipient read the pleading, read the discovery, and so on. And just the receipt does not take the steps further of the effect of a letter on a recipient. As this court addressed in Fletcher, I think we all know and believe that a lot of mail tends to be discarded. And for a letter in an envelope to have an effect on its recipient, the person must read that letter. TransUnion talks about a situation where a defamation statement is made in an envelope, or made in a letter, put in an envelope, sealed in a desk. It ends up having no effect on its intended recipient. That's similar to the case here. Appellant also argues that a survey could fix this issue, but in this case, a survey can't. A survey would likely be improper in the first place. How do you structure the questions to do this without hinting towards the result someone's looking for? And then last, Ramirez dispels any argument of future harm. Ramirez includes this multiple good analogies, but the main critical point of future harm is the future will tell whether or not those harms materialize. And time will tell whether or not that person actually has a harm from what is supposed to cause the harm. And so as Ramirez dispels the risk of potential harm, this case has no standing based because there is no present harm. There's only the risk of future harm, which never materialized. Ramirez and the cases leading up to it established Perez and the class here don't have standing under Article 3. Even if Ms. Perez has standing, the class does not have standing because there is no evidence whatsoever to support any actual injury for the class. As this court stated in Fletcher, people in the class that received the letter but ignored it as junk mail or gave it no meaningful attention lack Article 3 injury. But regardless of that, individual inquiries are necessary to flesh those questions out, and therefore this class also lacks ability to be certified under Rule 23.
Thank you, Mr. Martin. You've saved time for rebuttal. Mr. Devere?
Good morning, Your Honor.
I hope I pronounced your name correctly, but...
You're fine. Thank you, Your Honor. Your Honor, Brent Devere appearing on behalf of Mariela Perez and the class. That may it please the court. So, kind of as a starting point, there was already a finding as a matter of law that the underlying letter was false and misleading under 1692E. That as a matter of law, using an objective, unsophisticated standard, it was false and misleading as a matter of law. And then going forward from that point, if we look at the individual standing of Ms. Perez, they keep saying that she didn't have actual harm. Well, under TransUnion, we can only show intangible harm, and intangible harm would be enough to meet the threshold for concrete injury. So,
well, under the TransUnion case, as I read it, injury as a matter of law doesn't constitute injury in fact, and you have to have injury in fact.
Your Honor, it would certainly be strong evidence that there would be injury in fact, but we have independent evidence from just Ms. Perez's declaration alone that would support injury in fact, in addition to the objective finding. That she was confused, that she was misled, that she had to spend time consulting an attorney. Prior to TransUnion, as this court is aware, the Manuel Merchant's case that is precedent in this court, this letter would have been found to violate the FDCPA. It satisfied the requirements of Manuel Merchant's. It was false and misleading as a matter of law. It had deceptive language in it. The Merchant's court even cited that there was an inherent danger in the risk of making payments on a debt if there's no time-barred debt disclosure. So we believe that the type of violation is so extreme, it's an extreme form of 1692E, that it would meet the threshold for intangible harm, even under an objective standard. But even if the objective standard was not enough by itself, there was still independent testimony from Ms. Perez in her declaration.
But under Crawford, there has to be a showing of continued or threatened future injury, isn't that right?
Your Honor, we wrote in our brief that there was an imminent material threat of future harm, just the risk that any member of the class could make the payment. And then she also had the independent harm of confusion, being misled, being confused, having to take off time to consult an attorney, intrusion.
She did not make a payment, is that
She did not make a payment, that's correct, Your Honor. There was no evidence that she did.
It says that it has to be the traditional kind of harm, and the traditional kind of harm from a financial tort is loss of money, pecuniary loss. So, isn't that right?
That would be one type. I mean, the court did also say that they don't have to be exact duplicates, and we are dealing with an intangible harm, not a direct harm in this case. It doesn't have to be a direct harm to meet the threshold for concrete injury.
It has to be the traditional harm.
Harms that are traditional, yes, Your Honor, but that's pretty broad, and what that can be interpreted to include.
That one circuit said it meant pecuniary loss.
Pecuniary loss would be one type, but that would be more direct harm. If there was a pecuniary loss, I think that would be a direct harm, and that would be actual damages. So we don't have to have pecuniary loss to have intangible harm, which is also a sufficient threshold for a concrete injury.
What says that?
I'm sorry, Your Honor.
What says that?
For example, we cited Bassett, which is a recent Nebraska case in the 8th Circuit. It's up on appeal now, I believe, to the 8th Circuit. But that was a case where I think there was a failure to disclose the impact of prejudgment interest and the court ruled that was still a violation of, I believe, 1692E, even though there wasn't a requirement that a payment would have to actually be made. I mean, if there is an imminent danger of the risk by itself in conjunction with confusion, being misled, and other factors, I believe that would reach the threshold for intangible. I would emphasize intangible harm. Like I said, Your Honor, if she had actually made a payment in this case, let's just assume that would be direct harm, actual damages. But we're not required to only show direct harm in order to show concrete injury. I mean, in effect, if their interpretation was correct, then Manuel Merchants would no longer be good law unless there was an actual payment made, which wasn't required in that case. TransUnion was also made in the context of the FCRA, not the FDCPA as well. And in that case, there was also really more of an informational injury, if you want to even call it that, confusion over the type of formatting that was sent in the letter. Here you have a very highly deceptive letter that is probably the most extreme range of the 1692E pendulum with no disclosure whatsoever that it was time barred, requiring payment in full as an added layer of deception. So it may not trigger direct damages, actual harm, but I believe it meets the threshold for intangible harm, which is all we're required to prove. There was really not much of a challenge to Ms. Perez's individual standing in the brief itself that they filed, and obviously we're addressing it. But we believe that, also in answer to your question, Your Honor, traditional harms, the FDCPA in and of itself was enacted to protect consumers and to protect them from the harm and risk and basically the impact of bad collection practices. So I believe the Thumb case discussed that briefly. Arguably, the FDCPA in and of itself would be common law based harm or common bar based as a way to protect consumers as the traditional harm of being impacted by bad collection practices. But also the TransUnion case really, as far as future harm, said that there was really not a clear enough risk of future harm over and over again in that fact pattern because of the fact that even if the formatting letters were sent incorrectly, it was not likely that it was going to make a material impact on how the class members would react, that there was no real risk that having the OFAC alerts in their file would result in it being disseminated on their credit report. In Manuel Merchants, this court emphasized the danger and the risk of a partial payment that consumers can make if they're sent a false and misleading letter with no time bar debt disclosure. So the harm is much more, I guess you could say, imminent and material in this type of fact pattern. So if you have imminent and material harm in this case mixed with other aspects of harm that Ms. Perez and the class members had, basically confusion, lost time, arguably intrusion just by receiving a letter that's seeking to collect a debt, elements of deception. It may be short of actual damages, but it would reach the threshold for intangible harm. And then if we go towards the class itself, assuming Ms. Perez has standing, Article 3 standing requires preponderance of the evidence, not absolute certainty. So if the court has already made an objective finding that the letter is false and misleading as a matter of law, then under a preponderance of evidence standard, and also in conjunction with the fact that a letter that is sent is presumptively received, then we believe that there's at least a 50% likelihood that they also opened it and were confused by it using the same analysis that the court went through when it made an objective finding. It's not necessary that each and every member of the class would have to be formally interviewed and asked, were you harmed, under a preponderance of the evidence standard. If there's a concern that the letters were not received, I mean, they offer no evidence that they were returned, so they could have done that. So obviously, the FRCP 23 allows for a class notice by reasonable means, and I think by the same logic, the fact that the letters were sent, they can be presumed to be received, and under the preponderance of evidence standard to prove Article 3, we can assume that they've also been read and confused, just like Ms. Perez was. So it just would simply be excessive to require that the court conduct an individual case-by-case analysis to show intangible harm for each and every class member. It would be virtually impossible to do. It would render the whole point of the class action to some degree just simply not feasible. Unlike the TransUnion case, this was a uniform letter. I mean, it was basically, it was for all practical purposes, a clone from the lead plaintiff to the class members. In TransUnion, obviously, there was a significant break. You had one set of class members that had OFAC alerts that were broadcasted on their report, and then another that it was not. It was just kept in an internal file. And then the other part of it was they had arguably an informational injury because they received.
But isn't it important that it's not that the letter is uniform, it's that it is received and reacted to the same way by class members? Would you agree with that?
I would agree, Your Honor, that if the court finds that the lead plaintiff has intangible harm, then because it's virtually the same type of letter, and because we're using the least sophisticated standard, then I think you can assume by preponderance of the evidence that other members would react the same way without having to conduct an actual formal interview. I guess what I'm trying to say is that preponderance of the evidence standard means there's a really high likelihood that if a letter is found intrinsically false and misleading as a matter of law, that they would also have reacted the same way. I think that's the best way I could answer it. We did put in our brief that theoretically the court could even send an additional notice to the class members to specifically ask them, did you open it, were you confused, if that was even necessary. But like I said, under preponderance of the evidence standard mixed with the fact that it's an objectively false and misleading letter as a matter of law, I believe that would not make it that fact necessary to have to go through any further individual inquiry of the class members. I believe that's what the court also ruled when it made its ruling. Like I said, we're dealing with effectively a clone letter that we know well, under the Merchant's case and from this court alone would be, I think, found deceptive as a matter of law using the least sophisticated consumer standard. But I believe under...
But again, that sounds more like a legal injury in that the actionable conduct took place when the letter was written as opposed to when it was received by an individual who then read it and responded in a way that was damaging to him or her. I just want to understand your argument. Your argument seems to be, if I understood you correctly, that the letter itself, in being written and then in being transmitted, we go back to the other example, a defamatory letter that is put in an envelope and put in the writer's desk isn't actionable. But in this case, are you saying that because the letter was written and then sent, regardless of whether it was open, whether anyone responded to it, whether, obviously if someone got it and then made a payment that they didn't have to make or was they were legally not required to, it's a time-barred claim. Don't you have to go a little bit further than simply the writing of the letter?
Well, Your Honor, this is not a defamation situation.
No, I understand, but the analogy was made in the prior case and counsel cited to it. That's why I'm raising it now.
Well, you know, as far as them needing to open and read the letter, is that?
Well, I'm trying to identify the actionable conduct for purposes of class members, the same actionable conduct that the class members experienced.
The same actionable conduct that they experienced would be that they received the letter, opened it, and were confused and misled, the same way Ms. Perez was. But to do that, we only have to show by preponderance of the evidence. And I think a preponderance of the evidence with presumption of receipt would assume that they would open and confuse it by at least a 50% standard. One thing I was going to also mention was in Manuel Merchant's, I think it was in footnote 22, there was a cite to an FTC study that showed that consumers are inherently not understanding the impact of statute of limitations. That was also discussed in Doherty, which further, I think, bolsters the fact that the letter was false and misleading and could support intangible harm. And so I hope I've answered Your Honor's question. So we're not saying this is not like a defamation case. We're simply suggesting that the letter is false and misleading as a matter of law. It definitely confused and misled Ms. Perez individually just by her own declaration. On top of that, the court, in reading it, found objectively that it was highly deceptive and that we're assuming by preponderance of the evidence that the letters that were sent were opened and received and in conjunction with the presumption of receipt doctrine, all collectively. We're assuming that the letters were, by preponderance of the evidence, open and received and led to the same confusion that Ms. Perez had, without the necessity of doing a formal interview one-on-one.
What are some examples of intangible harm that have been held to be enough to kill standing?
Well, Your Honor, I mean, for example, intrusion and seclusion is one. Just as an example, like the Lupia case, I think that came out in the 10th Circuit, was based on a single phone call. It wasn't a 1692E violation, and this was post-Ramirez, but a single phone call was found to be an intrusion on a seclusion that led to Article III standing. So a letter that's deceptive, that's designed to trick or confuse or mislead a consumer, I think that could be arguably an intrusion on seclusion.
Well, the case law says confusion's not enough, isn't there?
I don't know if it necessarily says that. Some cases suggest, some cases have suggested that humiliation and confusion could be enough. I think we cited a number of cases. Thome was one case that we cited. That was, I believe, a 1692E violation, where it was an overshadowing case. And the court specifically said, well, they looked at the tradition of Article III standing and the history of the enactment of the FDCPA, and I believe they talked about confusion being sufficient. The individual debtor's testimony about confusion was sufficient to show intangible harm and concrete injury. That's a recent case. So it's kind of, I know, Your Honor, on the intangible threshold, it's different than the direct harm that he keeps talking about. Exactly locking in what exactly that is not the easiest thing in the world to do. Believe me, I've spent quite a bit of time thinking about it. But I really believe that confusion, humiliation, lost time, the overall impact that it could have on a person's life when it's an extreme false and deceptive and misleading violation cannot be overstated. I just know from my own experience that a lot of clients really are heavily concerned about this. They call us, they're worried, they take off time from work. So I think, to answer your question, I believe from that case alone that would support possibility that just the confusion and anxiety might be enough to support intangible harm by itself. And if it doesn't, you've got lost time, impossible intrusion on seclusion, and then the material risk of imminent harm based on the danger, as this court said in Manuel, that could result in a part payment and a concern being tricked into making a payment. Like I said, I know intangible harm is more of an unclear standard than direct harm, and it's kind of difficult to sometimes grapple with. But I don't think the facts in TransUnion simply considered a case quite like what I consider to be this case to being a very extreme 1692E deceptive violation. It was really much more of a kind of the concerns there were much more limited, and it wasn't an FDCPA case, it was an FCRA case. I could defer to a large degree to our brief in all other respects, but going back to the court's original question, the trial court did consider Ramirez. I don't think there's any doubt that it was considered in the decision. And like I said, the controlling law in this court prior to Ramirez, I don't think would have had much difficulty finding that this letter was false and misleading as a matter of law. And also, just to quickly...
You're just repeating yourself. If you have anything more to say, you have 2.5 minutes to do it.
Your Honor, maybe a very quick summary on Fletcher and Metacredit. I know that was discussed. That case never really reached Article 3 standing. I guess this case is sort of a continuation of that. In that case, it didn't satisfy the the Rule 23 requirements. So, I don't think this court has ever directly addressed whether Article 3 standing, in what context it needs to be considered for the class. But I think, in all other respects, I think that the cloneness of the letter and just preponderance of the evidence standard would support class certification and individual standing.
All right, thank you.
Thank you, Your Honor.
Mr. Martin for rebuttal. Not repeating the points you've already made, but rebuttal for anything that Mr. Devere said.
I will do my best to adhere to that. Judge Davis, I want to address your inquiry regarding tangible and intangible harms. TransUnion did address that and describe the tangible harms obviously as like actual harm, personal injury, monetary loss, and it goes into the intangible harms as reputational harm, disclosure of private information, or intrusion into seclusion. Which go in line with your typical common law causes of action, defamation, the intrusion upon seclusion. There was a recent case that we handled, Persinger versus Southwest Credit Systems, before the Seventh Circuit. It was an FCRA case where the defendant was alleged to have improperly accessed plaintiff's credit report. Her testimony was that she felt that her privacy was violated by that inquiry into her credit report, and the court found standing based on that. So that was an example of an intangible harm where the court found standing. However, this case, as I talked about, the common law aspect is different in this situation. The common law aspect most applicable in this situation is fraud or fraud by non-disclosure, and the elements just aren't met of that underlying common law action. Mr. Devere talked about how the letter has been found to be false and misleading. However, a lot of these standing cases that are cited in the briefs do have procedural type violations or FDCPA violations, but the court is still finding no standing because there's no injury that results from them. This is a case that falls in line with that. To have a misrepresentation in the context of this case with a letter, a representation has to be made. And so an unopened, discarded letter does not make any representation to the recipient. The letter has to be open, the letter has to be read, and the letter has to have some sort of effect on the reader, detrimental reliance that causes injury. There's none of that in this case.
What about losing time going down and money perhaps to get a lawyer?
For the class situation, there is no evidence of that. So you cannot have that. Ms. Perez, that is a tough one for me to answer. It's hard to establish, is that true harm or not? And leave it up to the court to decide whether or not those steps lead to harm, but she has shown no actual evidence of that time costing her money with other opportunities or her paying attorney's fees to handle that particular consultation or something like that. So before the trial court, there was no evidence of those events causing actual harm. In conclusion, this case has no concrete harm and therefore no standing under Ramirez. And then applying the Tataru versus RGS case that I referred to earlier, confusion does not amount to an injury in this case. And therefore, this court should find that there's no standing and instruct the court to dismiss this case, or in the alternative, at minimum, find that there's no class standing or the class does not meet the Rule 23 requirements.
All right, thank you, Mr. Martin. Your case and both of today's cases are under submission, and the court is in recess until 9 o'clock tomorrow.